We unpack. We unpack. We unpack. Coming to you live. Boxing Eagle unpack. Yeah. We unpack. We unpack. We unpack. Coming to you live. Seek and ye shall find. I told you that time was coming. The time is now. Now, Ryan Garcia has filed a counterclaim against Devin "The Dream" Haney. This is a legal process that Devin Haney's side has initiated. In this video, I'm going to break down what this countersuit is about on behalf of Ryan Garcia. I've already made videos talking about Devin Haney's complaint. This is newer, and your boy Ego obtained a copy of said complaint from Ryan Garcia, and it's some very interesting things. The longer video, but make sure you guys subscribe. Again, there's a lot of people who talk about it. You have content creators, they'll start reading an article somebody wrote, and then they'll look up the words they don't know and act like they're versed on what's going on. The difference between me and other content creators, I don't just talk about it, I show you. So again, Boxing Eagle has obtained a copy of this countersuit. No longer just about talking and, you know, giving opinions where the content creator doesn't show what they're talking about. So if you guys like this type of content, support it. Various ways to do it: subscribe, like the video, different options in the description, because these videos do take time. So again, if you like it, support it. In addition, I want to be clear. I ain't passed the bar, but I know a little bit. I am not a lawyer. I am not an attorney. This is not a prediction video for the outcome of this proceeding. I am not offering any type of legal advice. I am merely giving you my own expressions and opinions. So I want that to be duly noted, that this is just my opinion from what I read and interpret. If you guys feel something different, you know, feel free to leave me a comment. So let's begin. United States District, Eastern District, New York. Devin Haney Promotions. Devin Haney Promotions, plaintiffs, Ryan Garcia being sued, defendants, right? And let's go. Defendant Ryan Garcia's answer: affirmative defenses and counterclaims to the plaintiff's complaint, which indicates that this is a response to the lawsuit from Team Haney. So Team Haney initiated, they've received the complaint, they know they're in this legal process now. So the defendant, Ryan Garcia, his team would like to add their own countersuit, and that's what we're going to go over right now. Defendant Ryan Garcia, by and through his undersigned counsel, submits his answer, affirmative defenses and counterclaims in response to the complaint by the plaintiffs, Devin Haney Promotions, and alleges as follows. 1. Garcia admits that Devin Haney is a professional boxer. Garcia lacks knowledge or information sufficient to form a belief as to the remainder of the allegations set forth in paragraph 1 of the complaint, and accordingly denies the same. So I've already read through in preparation for this video because I want to be versed, because it's 33 pages, right? This was filed December 4th, and I want you guys to understand how this goes. A lot of this first portion of the countersuit is merely Team Ryan Garcia denying everything that has been levied against him in Devin Haney's portion of the lawsuit. Devin Haney is claiming battery, like the Energizer Bunny, but the other type of battery. He's claiming unjust enrichment, that like Ryan has profited from this circumstance, etc., etc. So a lot of these first sections are merely denial, right? Section 2, Garcia lacks knowledge or information sufficient to form belief as the truth of the allegations. So you have to go check my past videos to see each and every one. So I'm not going to go in, I have the Haney complaint and lawsuit too, but for the sake of this video and continuity, I'm not going to read all the complaints again. I've already done that. 3, Garcia admits he's a professional boxer. He further admits that he is a citizen of the state of California. Garcia denies the remainder. So you have to understand legalese. Every section where Devin is accusing this, that, and the third, they have to kind of like respond to. So that's what Garcia, his legal counsel, is doing. They're responding to all the claims. And, that's why it sounds almost a little bit redundant, but it's a court hearing, right? So it's like he admits he's a pro boxer. He admits that he's a citizen of the state of California, but he denies the rest. So that's what you're getting a lot of. Garcia lacks the knowledge, blah, blah, blah. Garcia admits that Dave Honig is a fitness trainer. Garcia lacks knowledge. So what you have here, 1 through 7 so far, is basically Ryan Garcia's legal counsel pleading the fifth almost, where everything that Devin Haney is, his legal counsel is claiming, he's only admitting to, hey, I'm a pro boxer. Hey, this is my age. Hey, I'm a male. Hey, I'm, a citizen of the state of California. All that other stuff, deny. So it's kind of like pleading the fifth. He's like, I have no knowledge of that. I have no knowledge of that. Let's keep going. Paragraph 8 of the complaint sets forth legal conclusions to which response is required, yada, yada, yada. Preliminary statement, Garcia lacks knowledge. So again, you see this whole section 9, 10, 11 is basically denying everything. Denies the allegations set forth in paragraph 14. Denies paragraph 15. So I'm just going to skip past this because, again, it's just really repetitive, but I understand it for the sake of a legal proceeding. You have to dot your I's and cross your T's. Garcia admits that he signed a bout contract for the bout against Devin Haney. Garcia lacks knowledge or information sufficient to the form of belief as to what Haney agreed to, and accordingly denies the same. Garcia denies the remainder of the allegations. So this is actually really good from Ryan Garcia's legal representation, because what the judge will see is they're responding to every complaint from Devin Haney in every paragraph and every stanza of the Devin Haney complaint lawsuit, right? And they're just owning up to the basics, like Ryan's a professional boxer. That's the only thing we're admitting to. So again, it's kind of like pleading the fifth, and that's what you kind of want to do in a situation. You never, in situations like court, you never talk more than you need to talk. So if you're on the stand, it's not like I've been on the stand, but I watch enough of these shows to know how it goes on and whatnot. But if you're on the stand and they ask you a question, just yes, no, keep it short, keep it brief. That's the best thing you can do. And that's exactly what Ryan's legal team is doing. No, we don't know what that's about. We deny blah, blah, blah. Garcia lacks knowledge of that. Garcia lacks, they're like, oh, but the strength and conditioning guy, you don't want to get incriminated by anything. So you just say, Ryan's a professional boxer, but he lacks knowledge of this. He lacks, so it's a smart play. Garcia admits the bout was initially for the WBC lightweight title, further admits that section 4.29 of the rules and regulations provides with the WBC doping and boxers, blah, blah, blah. Garcia denies the remainder of the allegations set forth. So he's only pretty much admitting to the basic principles. Like, yes, I signed a contract on this date. Yes, I'm a pro fighter, blah, blah, blah. Now, I'm going to skip around because, again, this whole front part is like this. So it'll just be, look, Garcia admits that after the weigh-in, he gave a urine sample. Garcia admits the bout took place on April 20th. So it's just kind of like the preliminary stuff. So we can kind of skip around. Lacks knowledge of information sufficient to form a belief on the truth of the allegations set forth in paragraph 37. Garcia admits that his representative stated the results showed trace amounts of ostarine. Now, one thing I will say is I have Devin Haney's lawsuit from Pat English. I've obtained a copy of that when that first came out, and then I got this for you guys. Ryan's actual suit is put together more professionally, in my honest opinion, because I didn't notice offhand from reading the whole thing any spelling or grammatical errors that just like stood out. But when it came to Devin Haney's complaint against Ryan, because he was the one that drew first blood like Rambo, Devin Haney's complaint had misspelled the word ostarine. You had one job to get that correct, and he had one banned substance that he tested positive for, and you misspelled the name of the one banned substance that Ryan had in his system, which is kind of crazy because you would think there would be some kind of spell check or proofreading before you submit. Why would you have grammatical and spelling errors and then turn the documentation into the court? That makes you look bad. So again, first impressions from Devin's suit versus Ryan's. Ryan, I don't know if, because he fought Tank, so maybe he made more money and his lawyer's like high price. I don't know. But Ryan's lawyer, I'm not finding no mistakes in terms of grammatical mistakes or spelling errors, but I did in Devin Haney's. And again, I can prove it. I can show you guys the errors in typos and stuff like that. It's just, it's not going to win or lose you the case, but it just looks unprofessional when you submit some documentation to a courthouse and you didn't even bother to spell check it, or the one drug PED that keeps coming up throughout this documentation, you keep misspelling it, or you're misspelling people's names and stuff. Not a good look. So we're on paragraph 40. Let's skip around. Garcia admits New York State Athletic Commission prohibited drugs list. The following is prohibited. So he's just acknowledging the bare bones minimum of what he needs to acknowledge and denying everything else, which again is smart. You don't want to say too much. You don't want to do too much. Garcia lacks knowledge, information, believe, blah, blah, blah. Okay. So now we're all the way on to, I believe, page 19 of 33. Count one. Count one is Devin's claiming battery. Ryan battered. I'm so sorry. It just sounds crazy. Ryan battered him, which basically is non-consensual touching. Devin's claim is that had he known that Ryan had ostarine or a banned substance in his system, Team Haney is alleging that they never would have like agreed to the bout. So they believe compensation is due because they had no knowledge of Ryan being on anything, and had they known, they would have operated different. But for me, I feel like that's a bit weird, and it's like kind of like a gray area because nobody knew that Ryan had ostarine in the system, including Ryan Garcia, because the test took weeks to come back. Right before Canelo versus Munguia fight, that's when the results came back. So Ryan's side could easily argue what they've been arguing. They're saying it's a tainted supplement and they had no knowledge of ostarine. They didn't intentionally ingest, which matters. So now I feel like Devin Haney's team would have to contend and find a way to persuade that Ryan intentionally cheated to try to beat Devin Haney, and he intentionally ingested ostarine and put that in his system, which, how do you prove that? How do you prove it? None of the evidence really that I've seen, unless they have like some kind of wild card, rabbit out the hat type of evidence, I haven't seen anything where you can say, hey, Ryan guaranteed what he's saying is plausible. There's case studies and reports where people tested positive for ostarine based on contamination or, you know, tainted supplement. Whether you believe it or not, it is plausible. And if you're saying that is not the case, you are filing the lawsuit, so the burden of proof falls on you. Now you and your legal team have to prove that Ryan battered you and went in here to cheat. And here's another thing. They fought 6 times as amateurs. Ryan beat him 3 times. So unless you believe that Ryan Garcia was juicing at those young ages when he beat him 3 times, then that kind of is something Ryan's legal team can use to their defense. Another thing is, what I do know about courts, they look for characteristics in like rap sheets and precedents. If a person is 28 years old and they've been in and out of prison, jail, and juvie since they were 13, 14 years old, they have a long history and rap sheet. And if some of the things that they were charged for look similar to what they're being charged for, the precedence is kind of there. Like, okay, why would we not believe you lost your temper and hit your manager when you have a history of assault and a history of battery and past jobs you beat up somebody, right? So in the case of Ryan Garcia, he's never failed a drug test, and it was publicly revealed until this Devin Haney fight. So sometimes you in a court scenario, you kind of have to give people the benefit of the doubt, unless he had a history of drug usage and or repeated infractions, like Dillian White. Dillian White failed multiple drug tests throughout his career, more than once in kickboxing and twice in boxing. So that looks worse because you've done it multiple times. Ryan, this is his first time. So it's going to make those charges stick. I feel like it's going to be more of an uphill battle because he doesn't have a long history of it. And I'm not saying that, you know, it's good or bad. I'm just telling you, they're going to look for character, and they're going to look for like, hey, you've been on drugs in the past, and they're not going to have that. There's no other competition where he popped dirty that I'm aware of. So let's keep going. Count 1, battery. Garcia repeats and realleges his answers to the allegations in paragraphs 1 through 48. So again, just denying everything. Paragraph 50, complaint sets forth legal conclusion, which no response is required. 51, complaint set forward, blah, blah, blah. So they're just going line by line, responding to Devin Haney stuff. Count 2, fraud. Garcia repeats and realleges, blah, blah, blah. So again, just deny everything. Garcia lacks knowledge. Unjust enrichment. Garcia repeats and alleges. So they're basically saying we already explained this. Look up. Count 4, the role of John Doe's and David Scooter Honig in aiding and abetting Garcia's torts. Garcia repeats and realleges, blah, blah, blah. Complaint is not directed. So very good. Count 4, the complaint is not directed to Ryan Garcia. All of these, like 66, 68, 69, blah, blah, blah. These are complaints against John Doe's mystery men and Scooter, Dave Honig. So it's like, we don't have to respond to that because this is not something you're complaining about somebody else, basically. Count 5, breach of contract, Garcia. So again, it's just going through the motions here. So let's get to some of the good stuff. All right, I think we should be about here. If you made it this far in the video and you haven't hit the like button, you should definitely consider it, because like I said, I'm gonna take my time with this boxing. There's a lot of people who just rush out videos, do quick 2-minute videos, 3-minute. That's not what we're doing here. of course, I could do condensed 3-minute videos, 4-minute videos, easy. But I want to take y'all through it and really show you. Like I said, I don't just talk about it, I show y'all. Okay, section 87, prayer for relief. Garcia denies the plaintiffs are entitled to any relief sought in their prayer for relief. Garcia requests the court deny all of the relief sought by the plaintiffs in the wherefore clauses and dismiss the complaint and all of the claims therein in their entirety and with prejudice. Garcia further requests he be awarded such other and further relief as the court deems just and proper. Now we getting somewhere. So basically he's saying like, this is felonious. This is false. These allegations are frivolous. Dismiss them immediately. Jury demand, no response, blah, blah, blah. Affirmative defensive. Failure to state claim. The complaint fails in whole or in part to state a claim upon which relief can be granted. Pursuant to Rule 12H2 of the federal blah, 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 the defense may be raised in any pleading allowed or ordered under Rule 7. Plaintiff request a prejudgment attachment is barred in whole or in part because it is not legally cognizable because of action and no motion, blah, blah, blah. Plaintiffs intentionally and voluntarily relinquish or surrender the known right, benefit, or advantage in connection with one or more cause of the action. Waiver, consent. 92. Plaintiff's claims are barred in whole or in part by the doctrine of consent because Devin Haney consented to the bout against Ryan Garcia. Oh my gosh. Now we are cooking with grease, people. So this waiver section, I believe they're saying regarding because remember the Haneyacks were crying, Ryan missed weight and then paid penalty money. And then the Haneyacks complained that Ryan was too heavy. But this waiver, they're saying you waived and surrendered your right when you agreed to the bout and took the penalty money. And then section 92 is saying the plaintiffs, Team Haney, DHP promotion, they're barred in whole by the ideology because Devin signed off to fight Ryan even when he missed weight, right? So how can you blame anybody when you agree to, like, we have a signed contract from you. So you don't like the outcome. I get that. Nobody's going to like the outcome, but Ryan's people are saying basically you got to live with it. You signed on for this fight. Fifth, affirmative defense. Assumption of risk. Plaintiff's claims are barred in whole or in part because Devin Haney assumed the risk when he participated in a bout against Garcia. So what I'm interpreting this as, they're basically saying you're a boxer, you know what that comes with. So as a result, you assume that liability. You know what this job entails. And there was no public knowledge of a failed Osterine PED test. So the bout was allowed to commence. So how can you blame Ryan Garcia in that instance? Which to me makes perfect sense. Like, you know what this boxing is, right? Like they have restaurants, right? Where they'll have you sign a waiver. Like, let's say they make really spicy chicken or something. And then on the spicier levels, you'll sign a waiver stating we are not liable if you have to go to the hospital because it's too spicy. You wanted to try this level spicy, so sign the waiver, we'll retain it. And that's kind of what Devin Haney did for the bout. We have a bout agreement, an amended term sheet. Even when he missed weight, you signed off on it and proceeded with the fight. So just like the example analogy I just gave, where you have a restaurant and they have extremely spicy food, like spicy Nashville hot chicken or whatever, and then you try the atomic those places oftentimes they have you sign a waiver. So if you pass out or something and then you say, oh, you got to pay for my ambulance bill, they're like, no, we don't. You assumed the risk. You assumed the responsibility. Section 94, sixth affirmative defense, accord and satisfaction. Plaintiff's claims are barred in whole or part by the doctrine of accord and satisfaction because Garcia paid Devin Haney $600,000 and agreed that Devin Haney would receive an additional 2% of the net event revenue otherwise owed to Garcia after Ryan Garcia missed weight for the bout, and because Devin Haney was paid a purse for the bout. Oh, Ryan's lawyer out here cooking. Oh, when I move, you move, just like that. Oh, I don't want to sound mad. I feel marvelous. D block. Ryan lawyer out here cooking. So he said, accord and satisfaction. This is what I said from day one. You, Devin Haney, agreed, signed a contract after Ryan missed weight, and you knew he missed weight by the 3.5 pounds, and you took penalty money and the 2% of the net event revenue. The moment you accepted his $600K and the 2% of net event revenue, it's your fault. If Devin is mad, you got to be mad at your team. Why did you accept that? Ryan said he'll give you $500,000 per pound that he's over. He was over almost 4 pounds, and your team settled for $600,000 instead of what should have been at least $1.5 million plus whatever the 2% of net event revenue. So it sounds like your team did you no favors by agreeing to this, and you thought you could still beat him with the additional weight. You even said that at the weigh-in. You said weight don't matter. He a C+ fighter. I'm an A fighter. I'm an A-level fighter, and I'm gonna get him out of here. Seventh affirmative defense, lack of causation. Plaintiff's claims are barred in whole or part because any injury or damages allegedly suffered by plaintiffs were not caused by Garcia's purported use of PEDs. So they saying that wasn't no Ostarine, that was that left hook. Garcia did not receive a benefit. Section 96. The plaintiff's claims are barred in whole or in part because Ryan Garcia did not receive a benefit for the bout, let alone a benefit at Devin Haney's expense. So again, and I'm sure they'll elaborate this when it comes time to speak on it, is people who pop dirty usually pop dirty prior to the week of the fight, right? Because the benefits are usually gotten in training. So you could push further, run longer, run faster, cover faster. That's where you cheat. You cheat when you're training for the fight. It doesn't really make sense, and that was always weird to me. It doesn't really make sense to wait till fight week and then say, hey, I want to juice. I'm having second thoughts. If you wanted to juice, if you wanted to cheat, most people do it in training camp. That's like going to a Arnold's, Mr. Olympia. Yeah, what is hey Kelly, like you're going to a Mr. Olympia and then you're just lifting weights all natural, straight natty, and then you wait till the week of the competition and the day before the competition, and then that's when you juice. So you never juiced the whole time you were training and bench pressing and all that. Weeks you were cutting and bulking, doing your diet. You never cheated then. You never took no anabolics then, but you wait till the day before the Mr. Olympia, and then that's when you do it. It kind of seems weird, and I think that's what they're kind of saying is like, how could he receive a benefit from one day's usage of Ostarine in that amount? 97. Plaintiff's claims are barred in whole or part because Ryan Garcia's purse for the bout was forfeited. And the commission told Ryan to forfeit the purse, not to Devin and Bill Haney, but to Golden Boy. And they're saying he already surrendered it. And now you're going to be hard pressed to get Golden Boy, who's Ryan's promoter, to say something different. They could just say, yeah, he gave us the money. They're not working with Devin Haney. They're not working with Bill Haney. So why would their allegiance be to them? So again, that's why I said Devin's lawsuit was kind of weird to me. Duplicative terms or claims, 98. Plaintiff's unjust enrichment count 3 is barred in whole or part because it's a duplicative of their fraud claim. So you're just trying to stretch it. That's what they're saying. 99. Unclean hands. Plaintiffs are barred from recovery, if any, in whole or part because of their unclean hands. And he said he didn't even wash his hands. Plaintiffs' claims are barred. Unreasonable delay in pursuing their claims. I don't know what that, I mean, unless they're saying they took too long. The fight was in April and you just waited. Unjust enrichment, if they were permitted to obtain, blah, blah, blah. Lack of injury. Claims are barred. This one's good because the plaintiffs did not suffer any injury or damage. Remember when, bro, the Haney's, it's like open mic night where it's like, it seemed very rookie to me. Remember when Devin Haney said, people said he had a broken jaw and they said he don't have a broken jaw? You got a broken spirit more than anything, but that's not something that's going to show up in a doctor's x-ray. So section 102 is saying that you didn't suffer any long-term, you don't have hearing loss or vision loss. You said you didn't have a broken jaw. So you didn't have no hemorrhaging. So what injuries or damages did you receive? You're saying that like your pride was beat up more than anything. You were in pain, some basic swelling, stuff like that. But you say you didn't have no broken jaw and no broken bones. You're on record saying that. So now, since his team is saying this, I would assume that Devin Haney, his side is going to have to counter that with, yes, we did. We went to the hospital. But then that's going to make Devin Haney look like a liar because he told the world days after the fight that he had no broken bones and no broken jaw because word on the street was he had a broken jaw. So you've already dispelled those rumors. So what are you going to do? Produce some paperwork and say, hey, the doctor said I need a backiotomy. Doctor said I need a backiotomy. Like, I don't know. It's looking weird, bro. 103, plaintiffs are not entitled to recover the alleged damages, if any, because they are uncertain, contingent, and speculative. Try to tell y'all, that's a good one. So what this is saying is there's sections of Devin's lawsuit where they're like, Ryan was on the shoulder programming with dazn and he had an IV and it had a yellowish tinge. What Ryan's lawyer is suggesting in this section 103, they're saying this is like circumstantial. This is uncertain and speculative. You're saying that he was using masking agents and, he was flushing his system, but you don't know what that was. Ryan can say, oh, the needle wasn't really in my arm. We just did that for show. Or he could say, oh, they were putting Kool-Aid in my system. Who knows what they would say. But the bottom line is you don't have the IV drip. So you don't really know what was in there. So I'm rocking with section 103. See, again, this is the difference between me and them. A lot of people talk about it, but I'm showing you and I'm explaining it in layman's terms for you. Smash the like button. So again, there's points in Devin's lawsuit where he's suing Ryan Garcia, but it's off conjecture. It's speculative. You're saying, hey, many people use IVs to flush their system and masking agents, which is true, but in the court of law, you have to prove that it is, without a shadow of a doubt, true in this case. You see what I'm saying? plaintiffs are not entitled to recover alleged damages because they failed to mitigate their damages. So he's saying their lawsuit, they probably didn't do a good enough job expressing what these damages, like what the real costs were. Like, were you scheduled to perform at the Grammys and then you couldn't make it because you got beat up and was swole up in the Ryan Garcia fight? Like, what happened? Like, what are the damages? You failed to actually outline it outside of a bruised ego. Like, what is your actual injuries? What are your actual damages? Like, if somebody beats you up with a crowbar, you could be like, man, I had a contusion, I had a concussion, laceration around my head. They're gonna have pictures. Man, I had to get 60 stitches because I got hit with the crowbar. He hit me. Like, you know what I'm saying? Like, you're gonna have something. What does Devin Haney have in terms of injuries? That's what they're asking. They're like, what? Speak on it. Like, what are the injuries? You haven't really said what these injuries and damages that you've suffered. Like, what weren't you able to do from this fight? Your record got overturned. You kept your belt anyway. So you were a WBC champion. The only reason why Devin Haney don't have the WBC belt now is because he didn't fight his mandatory when the WBC ordered it, which was Sandor Martin. But that has nothing to do with Ryan Garcia or Osterine. You became champion in recess because you didn't fight your mandatory that you paid step aside money for and then got scraped by Ryan Garcia. So you can't say, oh, I fought Ryan and I lost my belt because of Ryan, because you didn't lose your belt because of Ryan. You lost it because of you. You lost it because you didn't fight your mandatory, which Sandor Martin was the one waiting in line to fight you. So you still could have did that. And then when Top Rank won the purse bid, you gave up your belt instead of fighting Sandor Martin. So the damages are looking shaky because Top Rank was still interested in working with you and making the fight, but you elected not to fight him and became a champion in recess. Boom. You never know. Boxing scene. Top Rank wins purse bids for Devin Haney defense, but will he accept the fight? So again, I'm rocking with what Ryan's lawyer is saying. You lost your belt not because of Ryan. Ryan was never eligible for the belt because he missed the weight. So the belt was never an option, win, lose, or draw for Ryan, because he forfeited that when he missed the weight. It's all about that. Devin Haney's comeback fight from the Ryan Garcia loss was intriguing enough for Top Rank to make a $2.42 million bid to stage Haney's mandatory title defense against Spain's Sandor Martin. So again, I don't just talk about it, I be about it. What damages, bruh? You lost your belt because of you. Top Rank bid $2.5 million to work with you. So you're like, man, I'm Devin Haney. After the Ryan Garcia fight, I can't get opportunities. That's cap. You could have got opportunities and you could have had a good comeback fight with Sandor Martin, who, in my opinion, beat Teofimo Lopez. However, it says in bold lettering, Top Rank wins the purse bids for Devin Haney defense, but will he accept the fight? And Lance Pugmire spent all this time because he knew you weren't going to accept the fight. Matchroom didn't even bid on it. Devin says, wow, Matchroom, nasty work. So you're acting, I should have bid myself. So Devin Haney is looking real Karen-ish. He's blaming everyone. He said these beat promoters, that's the reason I haven't been back in the ring. I should have bid myself. Well, guess what? You didn't. You have DHP stop blaming other people, use your promotional company and put up the money and find the platform. You're your own promoter. You're your own boss. I had all the belts already, Devin Haney said. Top Rank says it's an attractive fight. That's why we put a bid in, Bob Arum says. You don't bid unless you believe you'll be putting the fight on. It's not like Haney got a lot of titles if he chooses to walk away from this one. So Bob Arum liked the fight, liked it enough to bid it, won the purse bid because Eddie Hearn didn't even bid for the fight. And then Devin Haney walked away from it and the opportunity. Matchroom's Eddie Hearn said recently he doesn't expect Haney to keep the WBC belt he won versus Prograis. The WBC belt is going to become vacant and Sandor Martin versus somebody will take place, Hearn told video reporter Sean Zattel. 100% he's not going to fight Sandor Martin. Who is going to pay for that? Well, Top Rank was willing to pay for it, but Devin Haney wasn't willing to fight Sandor Martin. So back to this lawsuit, the counterclaim, they're saying the plaintiff's claims are barred because they have failed to mitigate their damages. And I agree with that. What damage did oh, Ryan messed up my career. Top Rank was still willing to work with you. You were the champion at the time. You would have received the lion's share of the money, but you just elected altogether not to fight Sandor. That's a you problem. Top Rank showed the interest. They are contrary to established interest. Plaintiffs are stopped from recovery and hold because of their own acts and omissions. Garcia reserves the right to alleged additional affirmative defenses as they become known. Counterclaims. Listen, I'm going to leave it at that because I know this is a lot of information for you guys to consume. If you want me to go over the counterclaims, type in the comment section counterclaims and I'll make a part 2 of this video and finish out this counterclaim lawsuit by Ryan Garcia. And there's some parts it gets real rocky. Again, I'm not a lawyer. I'm not Ryan's attorney. I'm not Devin Haney's attorney. I'm just a guy with a YouTube channel giving you my personal opinions. But as I've stated, I don't just talk about it, I be about it. It's looking shaky because, first of all, you suing is nasty work. We haven't really seen this. Ryan's team, I think they're doing a good job of just like denying everything. They're denying everything except for the few things. I'm a boxer. I'm a citizen of America. I'm a citizen of California. I appeared in the fight on dazn network April 20th. That's the only thing they've agreed to. Everything else, they're like, throw it away, you know, with extreme prejudice, get rid of it. Doesn't make sense. Why should we pay? Why should we be liable to pay when Devin Haney hasn't even told us what his injuries are? Why should we have to pay when Devin Haney agreed to the bout? You assume the risk, you know, and everything I said in this video, and that's true. You took the man's $600,000. I've said this from day one. Why would you take a person's penalty money and then you have that in your bank account and then you continue to fight and then you blame somebody else because the fight doesn't play out how you wanted it to play out? That's not how that works. You can't really do that. You know what I mean? You can't agree to the bout. They have signatures. You think Golden Boy's stupid and they don't got the signatures? Of course they got the signatures, right? So even when he missed weight, you knew he missed weight and you still signed up for the fight. So you can't cry about the weight after. So I don't know. I don't know how to play out. There might be elements of Ryan's counterclaim that get rejected, but same thing with Devin Haney. I don't know. I guess we have to wait and see. But again, I think Ryan's counterclaim is put together. You know, I don't know if he's going to get the money he's looking for, 7.5 million and all that. I don't know all the details. We'll have to wait and see because it's not my call. It's the judge's call on what they deem. But it does look like he has a leg to stand on. And some of the points that Devin Haney's side is arguing, for me, it's just not making a whole lot of sense. It's an uphill battle. Like, the commission told Ryan Garcia what needs to happen and what his suspension consists of. Bill Haney's like, we want the money. We want a portion of the money. Nowhere in there. That's like a completely different. He failed. The commission said, you got to pay Golden Boy back the money. You got to give us $10,000 fine, blah, blah, blah. Bill Haney is saying, and Team Haney saying like, yo, we're entitled to some of that money. What? This is so crazy, bro. So crazy. Listen, like I said, I don't know what Haney's were thinking with this lawsuit. Like, again, I'm not a lawyer, so maybe my read is off. Probably not, because I'm the best in the business, and it's not even close. But there's a lot of stuff that I've read both complaints, and there's a lot of stuff. And like, let's be real, Ryan's complaint is basically, you're suing me first, so we're retaliating with what you did wrong, right? That's all that is. Like, if Devin never sued Ryan Garcia, I'm pretty sure Ryan wouldn't just randomly sue. He's being sued, and they're saying, okay, this is all cap, this is all lies, falsehoods, but here's what you did wrong. Since we're at it, since we're in court and we're pointing fingers and blaming, this is what you did wrong. So, that's just the legal motion that people will do because they're being sued. So they're like, okay, I got a case. I got a bone to pick with you too. But really, this is Devin Haney's doing. If Devin Haney never sued Ryan, I doubt that Ryan would take the time to sue, because for what? I mean, he's serving a ban and stuff like that. So I don't know. I don't understand what the Haneys thought that they were going to get. And this 103 hits. Plaintiffs are not entitled to recover the alleged damages, if any, because they are uncertain, contingent, and speculative. And if you look at the first lawsuit from the Haneys, they said that they're supposed to get like almost 50% or 47% of net event revenue, right? Net event revenue. But then in the contract, it don't really say what the net event revenue even is. Like, what is that based off? Is that, take home? Is it after this? Is it after this? So Golden Boy can say, we already gave you that, because it's not really clearly outlined and defined in the contract what the net event revenue is. Then the other thing that Devin Haney's complaining about in his suit is what transpired after Ryan failed a PED test with Osterine. They did an investigation, the New York State Athletic Commission, and then they ruled that the fight would be overturned. Devin wanted a win, which I told you wasn't going to happen, and it didn't happen. And from that, it just acted like the fight never happened. No contest, no decision, which I told you was going to happen. And then they outlined basically a consent order and protocol that Ryan needs to follow. Things like a year ban. You can't compete in America, basically, or definitely in New York, for 1 year. I think he had to pay $10,000 to the commission and undergo some kind of probably drug program or something. And also forfeit his purse back to the promoter, which shows you that the Haneys were never in charge, because it says back to the promoter, Golden Boy, because they were the ones, they were the main promoter, not DHP Promotions, right? Golden Boy was the real promoter of this, and that's with the consent order. So how are the Haneys going to raise their hand and say, hey, we want some of that revenue too? That should be us. When the contracts were drawn up, Ryan hadn't even failed a PED test. So it is impossible to have included the New York State Athletic Commission's ruling and consent order, because at the time you filled out the initial contract and signed to that, you didn't even know what would be later and what was to come later. So it doesn't even make sense that you are now claiming that because Ryan had to forfeit his purse, 100% of his purse, to Golden Boy, that you are a party to some of that money, when There's nothing in the contract that says that. There's nothing in the contract that says you're a party to this forfeiture, because nobody knew Ryan would have to forfeit his whole purse back to his promoter when you wrote the contract. So I know that's not something you would have included. Like, Ryan had never failed a drug test ever. So who's going to say, hey, I don't know, I got a funny feeling, even though I haven't lost a fight, because the contracts were signed before the actual in-ring combat. So who's going to say Ryan's never failed a drug test, I haven't lost a fight, I am confident I could beat him, but as an added measure, let's put in a clause, or let's put in a section in this contract that stipulates, should Ryan fail a drug test for Osterine, that we should be entitled to some of that money. Like, that's not how the law works. You're asking for money that wasn't even known about and present. That deal is a deal with the promoter, the real promoter, not DHP, but the real promoter, Golden Boy Promotions, Ryan Garcia, and the commission. That's really their business. Devin Haney is so desperate to get some money because his stock has been hit that he's filing a lawsuit for battery and like pain and suffering, all this type unjust enrichment. And then he's trying to get a portion of money that is really between a triangle: New York State Athletic Commission, Ryan Garcia, Golden Boy. That is the triangle. That doesn't include Devin Haney Promotions, whatever they discuss. Ryan failed to declare Osterine, or not Osterine, but he failed to declare the supplements, so he got suspended. That's what happened. So the Haneys are like, yo, we need a piece of that now that we know the commission made Ryan forfeit his purse. But there's no amendment in the contract that stipulates you're entitled to some of that money. So I don't really see how that particular money, how you think that's included in the net event revenue, which was never defined in the contract that I read, right? So I don't see how you're just trying to leech on and attach your name on to some money that wasn't even present when you signed the contract, right? And I know this might be over some people's head, but to me, it's not making sense. You're trying to claim the rights to money that happened in the future, that at the point in which you signed your contract, you had no knowledge that that money would ever be a thing. And you're saying, hey, I'm owed that. Like, what? How? That's like, if you're going to, I'm gonna try to make an example. Let's see if this works. If you're dating a girl and y'all are together for 7 years and you'll break up, and then after you break up, 2 months later, she plays the lottery and wins, and you're like, oh, I'm her ex-husband, I should be owed some of the money, or I'm her boyfriend, I need some of that money. It's not how it works. The only way that would work is if you were legally her husband still, and there was no like paperwork, separation, divorce decree or whatever. But if you were just a boyfriend, kick rocks. She won the lottery after y'all broke up. That has nothing to do with you. You guys get what I'm saying? You can't claim money, man, but I was with her for 7 years, and now that she won 10 million, I need a piece of that. Not how it works, bro. But again, if y'all want the part 2, put counterclaim or whatever I told y'all to put earlier. It's looking shaky for the Haneys, bro. And I really actually like what Ryan's team fired back with. They really clapped back. And again, I don't just talk about it. I've showed you. If you disagree, then let me know. And let me know specifics in the comments. Don't leave no BS comment. I disagree with you, and don't explain it. If you agree with me, love, and let me know. But yeah, I mean, even Ryan Garcia, some of his claims, maybe it's an uphill battle, but I'm not really tripping off that, because Ryan is not the one. He's not the aggressor in this lawsuit. This is just a counterclaim. So I don't think it's any skin off Ryan's back per se, whether he wins the counterclaim or not. You know what I mean? Yeah, legal fees and stuff like that. But I mean, obviously he doesn't want to lose to Devin Haney, but to me, the most of the burden is on the Haneys. The burden is on them to prove what they're saying. Prove that you're owed money that didn't exist until a month later. And then really longer than that, because the commission had to investigate. And then they finally ruled that Ryan had to return his purse to the promoter who rationed out the money. But somehow, some way, Devin Haney, they feel like, hey, we need a piece of that. That's part of what we agreed to. What part of the contract does it say that in the event that Ryan has to forfeit 100% of his purse, DHP Promotions is entitled to net event revenue? And this is why some of you guys got to get the right representation, because if you don't clearly define what things mean, you can run into this. Because if the contract doesn't stipulate in the event of cancellations or this or that or forfeiture, blah, 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 which it probably doesn't, then I don't see how the judge is going to see the complaint and be like, hey, that's included in the 47% of net event revenue, because that's not really net event revenue. I don't know if that's kind of technical. Ryan's purse, is that considered net event revenue? I'm thinking no. That don't seem like net event revenue. That's just purse that you got to pay out to satisfy the person to make the event. That's not revenue. That's not like positive ticket sales or concessions and merch or, you know, some kind of brand deal or something. Sponsors on the apron and on the ring. That's not net event revenue. And again, if you didn't define specifically in all situations, then it's not going to cover you. You know what I mean? And that's why, like, when people draw up contracts, you got to get the right people to review them, because one little comma or the addition of one word, it changes the whole dynamics of things. So, you know, you can get crossed up. That's a lot of these rappers getting 360 deals and stuff like that because they don't know how to read contracts. They happy to get on, and then they don't realize, like, man, this contract says I can't do a lot of things. I can't do a feature unless I get approval. I can't release an album on another label. You know, they're going to have all that stuff sewed up. So we'll see how it plays out. Let me know how I did. If you want part 2, let me know. We unpacked. Live streaming can be tough, which is why I use StreamYard. Click the link in the description for StreamYard, which is an awesome tool that enables you to set up your stream with ease of use. Get great results with live streaming. It's what I use. Stream to social media with ease with StreamYard. Live streaming is here to stay. Engage with your audience using StreamYard. Great way to reach out to your audience and connect. So you need a tool that can do that.